The Limitation of Actions Act does not apply to criminal offences. It is my considered view that the charge brought against the second accused person was not the proper charge. Section 157, Article 157 gives the power to institute and prosecute a person suspected of committing the offense to the office of the Director of Public Prosecution. And the question posed at this stage is, was there an offense committed when the second accused person gave a statement to the investigating officer at Langata Police Station, which turned out to be not true? I say no more. The office of the Director of Public Prosecution know their mandate. The result is that the prosecution did not adduce adequate evidence for this court to find the second accused person guilty of the offense of murder of Monica Kimani on the night of 19th of September 2018. The first accused person is convicted on the charge. The second accused person is acquitted of the offense. That is the end of the judgment. We move to the next stage. The state you are supposed to go next.
You're the first one.
So I am expecting the records. If any.
You'll be asking for no time. To present CRO report, which is the previous record for the first accused person who has been convicted. In the meantime, we'll also be asking for a pre-sentence report in relation to the first accused. And we'll also be praying that the first accused be remanded at Nairobi remand as we await to get the previous conviction and also the sentence report. We'll also be praying for type copy of today's version.
Okay. May I know whether Professor Nandwa, you have anything to say? No. There are victims' family. Musembi, sorry. Professor Nandwa, yes. Okay. Professor Nandwa, for the first accused person, you have something you want to tell the court?
Your Honor, first of all, we appreciate the system that this one and the court us to prepare our mitigation in favor of this person. We also seek the indictment with this one of the court that it maintains the bail terms that were granted to the person who have a convict. Please note of that first. We are very concerned the mitigation when required by this one of the court. We also pray that the exhibits that were and other items that were taken under personal nature, even the case has been included, demands specifically on the forms. That's
Work again.
My lady, in the last session we didn't take directions on dressing, so I feel that you excuse me on the dressing.
That's okay.
Thank you. The second thing, which is very important, is to thank you, my lady, for the attention to detail. You clearly gave attention to all the details, both factual, legal, and the issues in between, and we really want you to know that we appreciate as defense your attention to detail. The lady, for the second accused, we want to say, and we wouldn't want to take it for granted, sorry for the past accused. We are grateful for the acquittal on the charge that she was facing, and we pray, my lady, for the release of the securities that have been put in to study in Masaka.
You are asking for the release of security?
Yes, we pray. Yes.
That is.
Yes.
Well, you realize when this matter was going through that process, I wasn't hearing the matter. So what is it that was deposited in court? I think it's administrative.
Yes.
And for me, it should actually just be a natural process, administrative, unless, of course, the state, as I'll be indicating, have a right to appeal.
And they do not intend to appeal.
I do not know where you get that from. I don't know. That I'll leave to you.
Yes.
But of course, if they are not, after 14 days, you can seek for release.
Okay.
We need to give them the 14 days. Okay?
My lady, that's all we have for the second accused. Thank you very much.
Okay, so a matter of this nature, you cannot afford to pronounce a sentence without, of course, a bail report, because it is that report that will take into account the views of the victim's family. And so we will start over this matter to another date when we'll be dealing with the sentence. It will also allow the prosecution an opportunity to seek for CRO those records, so that the court is guided whether this is the first offense that the first accused person has been found guilty of and convicted of, and it will also allow the first accused person an opportunity to prepare mitigation. And then now need to take a date. We also allow the court assistant. We take a date for dealing with the sentence. diary. It's not my diary. Now, as I had indicated earlier, I'm starting my leave on Monday. I think, Professor Nando, you are aware of that because there are other matters that you have before me. And so, just to guide you, I'll be away from the 12th of February to God assistant. You don't have a diary where I can just quickly pick 24 February to 11th of March. You'll be before me on 12th. On 11th. Okay, so you want us to give you the 12th of March?
Yes, 12th of March.
You have two other matters that are coming for judgment before on 8th of March?
Yes.
8th of March.
8th of March. Can you make it on the
Okay.
You are also coming here.
Am I coming here?
Yes, 8th of March.
Yeah, it's a Friday. I come here on a Friday. Okay, 8th of March. Yeah, okay. I thought we were dealing with those matters virtually, Prof. You want me to come here? Okay. That's okay. I can. Okay. May I have the first accused person stand up? You will appear before the court on 8th of March for sentencing. Unfortunately, after conviction, I'm unable to accede and or allow the prayer by your counsel for you to remain on bond. I'm cancelling your bond. You'll be held in custody until the 8th of March.